Thank you, Sina.
Should I start?
Yeah, so
Okay.
let's go ahead and get started. It is 9:05. So good morning, everyone. This is Rebecca. Nice to see everyone's name on the list. So we are very excited today. We have Yvonne Lau joining us from HHS and OHRP to review a topic that I think is going to be really important for a lot of our work that we're doing here within OSEA. So Common Rule Essentials for our FDA CDRH OSEA group. So Yvonne, welcome. This is part of OSEA. There's a lot of other folks here that did have some other work. So thank you so much for recording this, and we are very excited for this session today. So just a quick administrative thought here is we're going to have a presentation followed by a moderated discussion. So my colleague Soma Cal will be joining, and Yvonne hopefully will be able to have a good and robust discussion after your presentation today. So thank you so much for joining us, and I'll pass the floor to you. Thank you, Yvonne.
So thank you, Rebecca, for the introduction, and I'm really excited to be here. And our group is very excited to be that we could be of assistance to you all and to help you with your work. So this particular presentation is tailored for the CDRH group. And I say that because, we've had some discussions, we get to know some of the work that you guys are doing. So we try to tailor the content to what would be of interest to you. So we're not covering everything in the Common Rule, obviously. We've scheduled the session for 75 minutes, although we've set aside 1.5 hours. So it's fine for us to stay for the full period of time, but if not, we could also end after a short Q&A session. So I'm hoping that this presentation will take about 60 minutes. All right, let's go. So first, disclaimer, the opinions expressed here are mine and do not necessarily represent those of the US Department of Health and Human Services. And I have also tried to simplify some of the regulatory language to make it easier for people to understand. And so in order for you to, just if you want to look at the full set of regulatory text, you should go to our webpage and look for the revised Common Rule. There's a hyperlink here for those of you who get the slides. You can actually just click on the hyperlink to get to the page where you can see the actual regulatory text. So here are the learning objectives. The presentation focuses only on the Common Rule regulations, not the FDA's regulations for clinical investigations. And I'm going to try to use the rest of the time to give you a very brief overview of how the Common Rule came about, explain some of the key concepts, specifically the concepts of human subjects research and the concept of exempt human subjects research. I will also go into a little bit more details on two exempt categories that I think is particularly relevant to the CDRH funded research. And last but not least, I'm going to talk a little bit about this thing called federal wide assurance and what this entails. So how did the Common Rule come about? So back in 1972, the New York Times reported about the scandalous syphilis study in Tuskegee, which immediately resulted in huge public outcry that led Congress to take some action. And with that, they created the National Research Act and establishing the National Commission for the Protection of Human Subjects. With the group in the commission, they were tasked with identifying some key basic ethical principles that should guide how we do research involving humans. And so there came about in 1979, the Belmont Report. Again, this is hyperlinked to our webpage where you can actually read the whole report. And the report actually formed the baseline on how, the regulations gradually developed and came about. And in 1991, the Common Rule was adopted across 15 federal departments and agencies. Now, the Common Rule was not modified or changed for some 20-some years. And however, recently there was, I'm sure most of you know, there was a revision to the common rule. And now we have this new set, which we generally refer to as the revised common rule, but the regulatory language is like the 2018 requirements. And generally now that we're so many years into the new set of common rule, generally when people refer to the common rule, it's really this new set of, this revised set of common rule. Here is, I just want to show you the timeline a little bit. So the compliance date for the revised common rule was January 21st, 2019. This is the general compliance date. There was the single IRB requirement. The compliance date was that for that was a little bit later. I don't want to say too much on this about this slide, but just pay attention not just to the date line here, but also like studies initiated on or after the date must comply with the revised common rule, the 2018 requirement. So anything that is initiated after this date, right? So initiated means a determination of exemption, or that it's been initially approved by an IRB, or that they were granted a secretarial waiver. We have very few of those studies. However, notice here on this left-hand side, to the left of the date line, studies initiated before this particular date. Institutions actually have the options. If they were initiated before, they continue to follow the pre-2018 requirements. So this creates a kind of a strange situation that I want to point that out to you, because I know that FDA, when you change your regulations, you don't normally do that. So we do actually have two sets, right? The pre-2018 and the current common rule that are in place. And that could sometimes create some confusion. So the HHS Office for Human Research Protections, OHRP, that's us here, right? We hold the regulatory authority for the Department of Health and Human Services regulations, as we call it, the human protections policies, at 45 CFR 46. And we provide the leadership in protecting human subjects in HHS conducted or supported research. In addition to that, we also provide leadership in and coordinates with the federal government's effort for protecting human subjects across the federal government. So we kind of coordinate with the other common rule agencies in terms of, when we were revising the common rule and also in its implementation. So the full set of regulations under HHS is referred to as the 45 CFR 46, and has 5 subparts to it. There is subpart A, which is the common rule, and then there are subparts B, C, and D. These are subparts that provide additional requirements to a selected group of vulnerable populations. B is for pregnant women, fetus, C is for prisoners, and D is for children. And then there is subpart E as well, which is really just an administration part on IRB registration. So generally, regulatory requirements for protections apply to something called non-exempt human subjects research. And I'm going to explain this term as we move forward. So non-exempt human subjects research that is funded by HHS or other common rule agencies and departments. Now, the other common rule agencies and departments, many of them, they would only have adopted subpart A and not the other subparts. And that's the reason why it's called common, right? We often ask why is it referred to as a common rule? Because that is the part that is part A. That is the part that has been adopted across the US federal government, many departments and agencies. So for the current rule, 20 departments and agencies have, using various mechanisms to incorporate that set of regulations into the human subjects research they support. Now, the common rule provides the foundational framework for human research protection. So the key components of the regulations, if you like, are actually in the common rule. In subpart A, in other words. Each common rule department or agency is responsible for oversight of the research that they support or conduct. Let's look a little bit closer at the HHS family, right? There's of course, we are in terms of biomedical and health research, that's mostly where people would look towards. And in the research community, there's quite a lot of confusion as to who does what within HHS. And in fact, FDA being so big, a lot of people may not even know that FDA is within the Department of Health and Human Services. And the same thing with NIH, right? NIH is also this huge giant, and people kind of think of it as like an independent, but it's not, as within HHS as well. And just like us, we are within the office of the secretary. So our little office, we are tiny by comparison to you all. And we reside within the office of the secretary, but we are all part of the HHS family. Now, for HHS sponsors of research, so the giant like NIH, right? They fund and administers research grants, and they do actually write policies, right? Policies that all their grantees will have to follow if they're going to get money from NIH. But that set of policies should, must actually comply and, wouldn't say comply, but be compatible with the HHS set of regulations for human subjects protections. Now, the FDA, as most of us know it, regulates clinical investigations involving drugs, devices, and biologics. I don't have to explain that to you. You've worked in FDA. Right? But occasionally, and your role is to make sure that all the stuff will be safe for public consumption. Occasionally, however, right, you guys also sponsors and conducts research. Now, our role here is that we're the regulator. We have the authority over the HHS conducted or supported human research. So for example, let's take NIH, our biggest client, right, so to speak. All NIH non-exempt human subjects research comes under OHRP's oversight, right? So NIH research that are also clinical investigations involving drugs, devices, biologics will also come under FDA's oversight. And for those of you who are familiar with your set of rules, I'm not too familiar with it, but for all those of you who work with your rules, you know, and if you know a bit about the common rule, you probably realize that, or you've probably heard people saying that there's a lot of similarities. I mean, they're kind of based on the same principles, and they did come from, a similar origin. But then there are distinct differences as well. And of course, there is a huge harmonization effort going on that tries to, make the two sets of rules as similar as possible so that people don't get too confused. And so what happens when, a particular research comes under both sets of rules? I think, this is for my compliance colleagues to say, but as far as I understand, our compliance colleagues would probably let FDA take the lead and then look at what else, we, on our end, that our jurisdiction would expect and would require, and then we'll look at it from that side. So we work together a lot. So what then is in the common rule, right? What is this about? What's in it, right? So there are the nuts and bolts, which I would consider like things like definitions, right? Conditions for exemptions, and then what are the requirements for filing assurances to the federal government when people get money from the federal government to do human research, right? And then there are the requirements, the regulatory requirements. There are specific requirements for setting up the institutional review board. What is the membership structure? What functions they carry out, how they operate, and then record keeping. And then there is also specific criteria for how IRB would review and approve research, right? So what mechanisms they use to review research. And then there are the requirements specific to informed consent, right? Informed consent supporting the ethical principle of respect, right? What requirements, what investigators need to include in the informed consent, and how the consent need to be set up, like, using language that is understandable and providing people with information that they would need to make a decision about participation or not. And then there are other stipulations and requirements that may relate to other institutional responsibilities, or sort of reporting of incidences, adverse events. Well, we don't use adverse events. We use the term unanticipated problems, right? So there are those requirements as well. So how does it work, all right? When do regulatory requirements apply, and what does that mean? So the common rule regulatory requirements typically apply, right, when a project is non-exempt human subjects research. And when that happens, this means, amongst other things, that those things we just talked about that constitute regulatory requirements, specifically referring to IRB review, right? The structure of the IRB that review the research, the informed consent requirements, right? And then the institutions receiving the funds need to have an active FWA, federal wide assurance, with that's filed with OHRP. And then there will be need for IRB certification that the research has been reviewed and approved according to the regulatory criteria. So typically that's what, what we mean when we say the regulatory requirements apply. Now, when do the regulatory requirements, typically not apply? When a project is not research, right? That wouldn't come under the jurisdiction. When the project is not human subjects research, right? That would not come under the jurisdiction. And when the project is human subjects research, but is exempt, right? It fits into one of the exempt categories described in the common rule. Under all these situations, that means that investigators and institutions would have the flexibility outside of the common rule regulations to do the research in the way that they want. So that could mean like, okay, well, we're gonna, this is, this does not come under those categories. We are doing this project, this activity, we're still going to go up and ask people if they would, want to participate, but we may not, we get their agreement, but we may not, present them with a full, informed consent form as prescribed by the common rule, right? Whatever that is the case, right? Ethical responsibilities towards the participants, right? To protect their rights and welfare remain, right? Ethical responsibilities, we always have that when we interact with people and when we ask people to help us with our projects. So what activities, therefore, are so-called non-exempt human subjects research, and how do we make that determination, right? After all, it becomes really important for us to know whether the set of regulatory requirements are going to apply to the activity that we are conducting, right? So we make that determination by asking the following questions in this order. And I cannot emphasize that more, in this order, right? So first, the very first question is, does the activity involve research? Second question, does the research involve human subjects? And third question, is the human subjects research exempt? And all these words that are bolded have their own regulatory definitions. So the important thing often when we do this kind of webinar with investigators and the people in the research community is that, notice that these are definitions, these are regulatory definitions for research, human subjects, and exempt, right? It's not, it's not your own definition of what constitutes research, right? Because people use that word as a lay term as well. And this is a flow chart to, again, show you what we meant, right? So is it research? If it's no, then basically you stop. You don't even have to think about the rest of the common rule, what are the requirements and so on. It doesn't bother you. It shouldn't concern you. However, if the answer to your first question is yes, then you move on to the second question, and then the third, right? As you can see here. And it's only when you exhaust it, when you come to the last part and you say, okay, well, this is human subjects research, and it doesn't fall into any one of those categories, exempt categories, right? Then it's non-exempt human subjects research. And for non-exempt human subjects research, right, then we start looking at how the common rule requirements would apply to that particular activity. So let's look at all these different definitions and how we think about them. So does the activity involve research? In the common rule, research is referred to as a systematic investigation, including research development, testing, and evaluation, designed to develop or contribute to generalizable knowledge. It's just left at that, right? But the idea is really this concept of, researchers would have, it's prospective, right? It's prospective. You're looking forward, right? You have investigators would have a question, a hypothesis, right? And in order to respond to this hypothesis, they set up, some methodology, the design, right? And then to collect information in order to answer that question, right? And of course, hopefully, we're all doing this with, it wouldn't be worth the federal government's effort and investment, right? If we investing in something that is not going to contribute to something that is generalizable and be, beneficial to the common good, so to speak. So that with that definition, under the revised common rule, we've added 4 types of activities that are deemed not to be research. Not anything particularly special about them, but it's really, in the case of scholarly and journalistic activities, it's just that in the pre-2018 situation, there were a lot of confusion to the research community as to, whether this particular activity constitute or not. I mean, so we just made it clear for them, right? So it's not any time that something fit into a scholarly or journalistic activity, it automatically is a carve out. No, there are some specific details to it, but I'm not going to go into that because it doesn't really concern your group so much. The other 3 are government functions, and you can see number 3 and number 4 related to, information collection for criminal justice, operational activities, national security. Honestly, I know nothing about those things. I'm not even going to go there. However, the part that may be of concern to us and of interest to us is the public health surveillance activities, and that's where I'm going to go and say a little bit more about. So this is a public health surveillance activities carve out, and it really only apply to activities that are conducted, supported, requested, ordered, required, or authorized, or all these verbs, right, by a public health authority. So the one thing that you need to pay attention to is that it has to be coming from a public health authority, and there is a definition of public health authority in the revised common rule. I'm not going to, give you the full definition, but in general, really is, any organization that has a kind of a public mandate, right? So they have some sort of authority, whether it's a local government's authority, state government, or Indian, sovereign authority, etc. So there is the group has some authority, a public health mandate authority, and they're conducting these sort of activities, right? Activities necessary to allow a public health authority to identify, monitor, assess, or investigate potential public health signals, onsets of disease outbreaks, conditions of public health importance. So including all these trend signals, risk factors, patterns of disease, or increases in injuries from consumer products, right? So potentially when it's this kind of activity and it's, conducted, supported, ordered by a public health authority, then potentially this public health surveillance activity carve out could apply. And it includes activities obviously associated with timely situational awareness and priority setting during the course of an event or crisis that threatens public health, just such as the COVID pandemic. So let's look at some examples, right? On the left here, let's look at one that will fall within this public health surveillance, and it would not be considered research potentially, right? So a physician reports what appears to be an outbreak of an unusual type of meningitis. And in this current, period, I can replace that with the monkeypox, right? A public health authority across the country now and across the world, they're collecting just patients' medical and demographic information to watch out for, its development, the signals, right? Is it coming to the States? Are we having more cases? Should we be worried about? Now, that's typical a public health surveillance activity, and it could most likely, would fall within the carve out and not be considered research. I said most likely and would fall within. Is it sometimes, depending on the public health authority, right? They may want it to be, seen under as a research, so that there are some, more oversight to it. But, in most situations, that would be the typical kind of activity public health people do to protect our health. And so, that kind of activity will not be considered research. Now, on the right here, that's an example of what may seemingly be a public health initiative, then cross over the line and become research. So public health authority has a hypothesis, right, that certain environmental exposures and lifestyles may result in an unusual form of meningitis. To test this hypothesis, they plan to collect medical, demographic, family history, and behavioral to study and to answer, to respond to this hypothesis they have, to answer this question. Now that kind of cross over to research. So I guess in real life situation, and let's take the monkeypox situation, right? It may be, I put the examples in such a way that they're kind of clear that what constitutes, public health surveillance activity, what may not, right? But in reality, sometimes activities may not be so clear, and we have to really think about it carefully. So OHRP did publish a draft guidance on our thinking about this so-called public health surveillance carve-out. And it was published in November 2018, and you can access it through this link. The purpose of the surveillance, OHRP clarified, is really to directly inform public health decisions or actions that could only be made by a public health authority. Right, still clear as mud, I guess, in reality, but I think it's clearer, right? It's kind of give you the sense that it's really to directly inform, important public health actions and decisions that they need to take now. And in the draft guidance, it also talks about it include as eligible examples, right, safety and injury surveillance activities. And look at here in brackets here, there are things that are such as the surveillance activities of FDA's adverse event reporting system, the vaccine adverse reporting system, etc. So, all right, I put that there for you because, as we talked to Rebecca about the kind of things that CDRH does, well, could your activities potentially fall within this public health surveillance carve-out that is not even considered research? I can't answer that question. It's really for your agency and certain people in your agency to kind of come up with a policy as to how you would apply this carve out. And I have been told, I had the opportunity to ask who to ask, right? So you have an office of the chief scientist, office of the commissioner. So office of the chief scientist under the office of the commissioner for FDA. So the person there's a human subject protection executive officer. That's the person that you need to ask. And the person who has that position now is Bridget Foltz, Foltz. So that's the person that you need to ask. I know I have recently spoken with her, and she said, no, they haven't got a policy yet on this. So, to follow up with. Now, separately, I want to just share with you something that my boss mentioned to me. So apparently there's also a 2006 OHRP guidance related to something to in vitro medical device clinical investigations conducted under 21 CFR 50.23E that clarifies. So in this guidance that OHRP published, we clarified that the use of an investigational device only to, one, identify potentially life-threatening chemical, biological, radiological, or nuclear agents, two, facilitate the treatment of individuals exposed to such agent and or report test results to a public health authority would not be engaged in human subjects research under the regulations. So if you've heard what I've just said, I kind of, without having to repeat it again, I kind of think that it does actually fit quite well into this directly inform, something that is being done to directly inform public health decisions or actions on something that is of clear public health importance, and there's some sort of urgency and situational awareness type of background to it. So if you're interested in that, I did include the link to that guidance at the end of this set of slides, so not right here. All right, with that out of the way, we're going to go to the next question. So the first determination was, is the activity something that would fall under our definition of research? Now we're assuming that yes, it does. Now we move on to the next question, because if it didn't, we don't even have to consider the rest of these questions, right? So it did, and now we're moving on and we're asking, okay, what about human subject, right? Human subject under the regulations is defined as a living individual about whom an investigator conducting research obtains information or biospecimens through interventional interaction with the individual. Intervention is kind of doing something to them, invasive, perhaps, something like that. Interaction is more like, interacting with them and having a conversation or asking them to do a survey, that sort of thing. And uses, studies, or analyzes the information or biospecimens that are collected through this means. or, so there is the second part of the definition. It's an or, okay? So a living individual about whom an investigator conducting research obtains, uses, studies, analyzes, or generates identifiable private information or identifiable biospecimens. So the key word here is identifiable. So definition for the associated terms, you can look them up in the regulations, but as I've said, intervention, physical procedures by which information about specimens are gathered, but it also includes the manipulation of the subject or the subject's environment performed for research purposes. So there is this part that people often forget, and interaction is the communication side, the interpersonal communication. Now, identifiable, for the second part of that definition, identifiable is the key word, as I've said. So identifiable private information or identifiable biospecimens under the common rule refers to private information or biospecimens for which the identity of the subject is or may readily be ascertained by the investigator. Here we say investigator, but it's really the whole investigator and his or her team, right, working on that project. Or, right, the identity of the subject is associated with the information or biospecimens. Now, that is our definition for identifiable, something that is private information or biospecimens that are identifiable. We have the revised common rule says that, there will be the opportunity to look at the definition of this word every 4 years. As far as I know, this definition has really remained the same as what it was in the pre-2018 rule, and I have not heard anything otherwise at the moment. So it's a more sort of abstract type of concept, unlike other ones that you've seen. So the common rule does not define other associated terms. So things like coded, de-identified, anonymized, right? People often ask, well, what about coded? What about I'm going to show you a way of how the logic works, but if you actually just give us these words, it doesn't mean anything to us when we're trying to interpret and apply the common rule. It does not have a list like the list of identifiers, all right, list of items that are considered, right? If you have these, then this is identifiable. We don't have that like the HIPAA identifiers. And then the other thing that's of interest is that sometimes unique identifiers, such as fingerprints, may not necessarily be identifiable under the common rule, right? Think about it. So yes, researchers may be looking at 1,000 different fingerprints to do something, right? To do some analysis, right? If they don't have like the information that links each set of fingerprints to a living individual, then they don't have, then this identifiable definition does not apply because it's not readily ascertainable by the investigator. And the fingerprint itself, right? It's not really associated. It cannot really say that, well, it is, it is unique to the person, but you can't really associate it with that, person easily. On the other hand, interestingly enough, we do actually generally consider facial images, right? So if you take a picture of me, or voice recordings of individuals, generally we would consider those as identifiable. Now, this is a peculiarity because it's a more conceptual type of definition and it's more open up to interpretation. Now, we're going to move slightly away and talk a little bit about this concept called secondary research. This is the research use of information or biospecimens originally collected for non-research purposes. For example, so if this is, information or biospecimens that are collected routinely in the clinical setting, not in the clinical setting, for clinical use, that's really more correct. So if I go to the doctor and the doctor says, oh, let's take some blood from you, blah, 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 and, and ask me a whole bunch of questions, put it into the record, right? All that is collected because of my clinical care visit, right? It's not collected for any other reasons. Now, if researchers come and use that information that was collected through my clinical care or some of the leftover blood specimens to do research, that would be secondary research, right? Now, or, right, the research use of information about specimens originally collected for research studies, but not for the one that is currently proposed. So, there is a there are plenty of things that have been collected from all the research that we've done over the years, right? Investigators, they might have started doing a research on drug study on Alzheimer's, right? And, somebody else came along, or, some sort of students come along, and they're actually interested in looking at, early onset diabetes. Does that predispose to Alzheimer's, right? So it's kind of like a different project, right? So they can go back and ask the investigators on the original project and say, hey, can you, share some of your information with us, and, so that we can do some analysis for this other project. So this kind of relationship, yes, the second one will be secondary research. Just want to explain this concept of secondary research. So there's secondary, then must be primary, right? So there's not a definition for primary, but essentially, if you look at the regulation for regulatory definition for human subject, you can see where we're going with this. So remember the definition, human subject, living individual. There were two parts to that definition. The first part, obtain information or biospecimens through intervention or interaction with the individual. In other words, you are interacting, you are interacting and intervening with that individual for the purpose of the research. That is what we refer to as primary research. And if you're not doing that, right? So the or part kicks in. We just explained it. That's when that secondary research kicks in. Now, in secondary research, there is no intervention or interaction done with individuals specifically for the purpose of this research. Everything would, information on or biospecimens and stuff like that would have come from other interactions and interventions that have happened or are happening because of reasons that are not associated with this specific research that we're talking about. That's what we need to understand. All right. So for the second part, right? So if it fits in with that, so you're going to ask somebody, some clinicians, right, for all the data to do some analysis, right? And you're not interacting or intervening with people specifically to get information for this project, then it would be secondary human subjects research. And it may qualify for an exemption. If not, you follow regulatory requirements for IB review and informed consent. This refers to if you're using identifiable private information or identifiable biospecimens. What about if we are getting it from people and they're not divulging anything that is associated with that individual? And when we receive it, we really cannot link it back to living individuals. So there's no, the identifiable part does not apply. Then you are doing secondary, but this is not human subjects research, because only non-identifiable materials are being used for the research. And see how I lay out the definition for human subject here for you. The first part does not apply. The second part does not apply. So hence, this whole definition does not apply. It's not human subjects research. It is secondary research, but it's not human subjects research. And remember what we said, if it's not human subjects research, then it's also outside of the common rule in terms of, you don't have to think about all the common regulatory requirements anymore. They don't really apply to that project. So I've talked about these terms like coded, de-identify. We don't know what they mean, but we can use the same logic to see how it works, right? So when research involves only, right, the entire research involves only coded private information or coded biospecimens and meet both the following. Investigators do not, I miss a T there, do not interact or intervene with subjects to collect the materials for the purpose of this research. That's secondary research, right? So this part it's not happening, so it's secondary research. And investigators cannot readily ascertain the identity of the individuals to whom data and biospecimens pertain, the specimens pertain. So plus, they only uses non-identifiable private information or non-identifiable biospecimens under our definition of identifiability. That equals not human subjects research. That's how we kind of apply that logic to these terms that people commonly use, but we have no definitions for. So we look at exactly what they're doing and what they're getting and whether they fall within our definition of identifiability, and then make that determination. All right, so we've kind of finished with the definition of human subjects. Hope that you got all the information out of it, and now we're going to move on. So assuming that after we looked at the activity in front of us, we made a determination that it is research under the definition of the common rule, and the next question is that it is human subjects research because the investigators have access to identifiable materials, right, that other people have given them. Right. Okay. Now, then the next question that we want to ask, or the other possibilities, of course, the investigators are doing like clinical trial. They're going out to interact and intervene with people, right? So they're actually collecting specifically for the research. So under those situations with human subjects. Now let's move on to ask the next question. Okay, now we know it's human subjects research. The next question to ask is, does it fall in within one of the exempt categories allowed in the common rule? And we're talking about the whole research, right? So not just parts of it. There are 8 exemptions in the revised common rule. In the pre-2018, there were 6, and one of them was different from the one that we have now. But anyway, so we have 8 sets of exemptions. I'm not going to go through all of them. You have the information here. Notice that none of these exemptions are applicable to research in prisoners' research. If you have under the revised common rule, there's something that is interesting. So you could be doing research and an exemption applies to your research. And unfortunately, that one or a few of the subjects, actually, because of the type of research, they get arrested for something. And then the people often come and ask us, well, does it make it prisoners research? Do we have to take the person out of this research now because exemption does not apply to them? I think in the revised common rule, we've kind of expanded that. And so if it's something that is incidental only, in other words, your research is not really targeting or directed specifically to look at the prisoners population. It's really to look at the general population. And you just happen to find out, or you just happen that there are a couple of people in it that turn out that they have, have the status, right? You don't have to, because of them, not be able to use the exemption. And some of the exemptions also do not apply to children. So I want to draw your attention to 2 exemptions specifically. Exemption 2, educational tests, surveys, interviews, or observation of public behavior, and exemption 4, which applies to secondary research. And the reason why I want to draw your attention to these is that I think that they would have some relevance for some of the work that you do. But okay, let's just look at what does it mean when we say that a human subjects research set of activities are exempt, right? So obviously the whole project fits into the conditions, right, required for that exempt category to be applicable. So human subjects research activities that meet all the conditions for an exemption category are exempt from the regulatory requirements of the common rule. We've talked about that, that these would generally be the informed consent requirements and IAB review requirements. Now, in the common rule, it doesn't actually stipulate who makes the determination of the activity being an exempt human subjects research, right? But generally, OHRP does not recommend investigators make that determination because obviously there's some conflict and there would be some bias with investigators making that determination. And of course, the danger, if you like, is that if the determination is made wrong, right, erroneously, that something is really not exempt and really not all the conditions of an exemption apply, then it would be out of compliance. And you're literally talking about, well, something that should have been a non-exempt human subjects research and should have had the oversight of a proper IRB board, etc. Those were not applied because somehow they thought erroneously that it was exempt. So hence, most institutions would generally rely on people who are experienced in the IRB, experienced individuals are working in the IRB office. Often, these may be IRB professionals, IRB administrators, and many of them, probably would have a role on the IRB anyway. So most of them may be also an IRB member, but it is not required for them to be. Now, making exemption determinations are not the same as, doing the review and approval through that, regulations require type of IRB review. So the revised common rule, just to make sure that they continue to confuse people endlessly, right? So they introduced this new concept called limited IRB review. And this limited IRB review applies to certain specific exemptions. And what it means is that when people have want to make determinations and say that that particular exemption provision applies, for that particular provision, it might require something called a limited IRB review. And what it is that it's just a one-off review. It requires an IRB person to do the review, right? But all that person reviews, at least from the perspective of the regulations, is that they only need to make sure that the conditions that are described for that exemption apply. Now, these are all aspects from the regulations, and sometimes we would say the regulations form the floor, right? Institutions and IRBs, mostly institutions, would have the right, if they want to be more protective, they can, add more to it. And, it's really a situation where you want to make sure that the research continues to generate public trust and the ethics, it's done ethically and so on. So there are other reasons why people might want to be a little bit more restrictive or have more sort of policies above and beyond what the common rule regulatory requirements say. So I said that I would say a little bit more about exemption 4 and 2. So here it is. Exemption 4 is the main exemption that would be useful for secondary research use, right? And of identifiable information or identifiable biospecimens. Now, remember, we've already said secondary research use of non-identifiable materials, right? Private information biospecimens, that's considered not human subjects research. So that's already kind of outside of the common. You don't even get to this consideration of whether something is exempt or not. So under exemption 4, there are 4 sets of provisions that may work, again, for secondary research. So first, provision, when the identifiable materials are publicly available. So I don't know, I mean, I guess, let's take an example like mugshots. I've heard that, people's identity would be associated with those mugshots of, people who've been imprisoned or something. And researchers come along and want to, do research and make analysis on that. And in the health setting, I guess, there's often the question of like people going to Facebook or going to the social media platform to do research, right? So just remember there the regulatory side of whether something is identifiable or not, and whether you can use this exemption for the research. But then there is also sometimes the ethical consideration and people's concept about privacy. There may be some discrepancy between the two. But from the perspective of the regulations, right, if it falls within this, you're doing research, it's secondary research, and you're making use of identifiable materials that are available publicly, then yes, exemption 4 provision 1 would apply. And that means that your research would be exempt from the common rule. You don't need to go through an IRB review board. Now, the second provision is the most common one that is being used and most relevant to most people. So it is information, which may include information about biospecimens, is recorded by the investigator in such a manner that the identity of the human subjects cannot readily be ascertained directly or through identifiers linked to the subjects. And the investigator does not contact the subjects or re-identify subjects. Notice that this is interesting, right? We start by saying this exemption applies to secondary research use of identifiable information or identifiable biospecimens. And then you look at this provision, it reads like, okay, well, it says that there shouldn't be this link, right? So what's happening here? What's happening is that investigators often start off, they may have access to information and biospecimens that have people's identity associated with them, right? So a clinician working in a hospital, right? They can access medical records and things like that. But what happens is that would not fall under not human subjects research to begin with, right? They have access to identity, but for the purpose of the research, they're just going to maybe download a set of data, and in that data set that they will work it going forward for their research, they have removed the identifiers, if you like, right? They have not included, information that would enable them to be able to readily make, ascertain and link the materials, right, back to the living individuals. Right? So it's that kind of a situation that we would use exemption for. And in the revised common rule, we've added, additional language to make sure that it's clear that, hey, if you use this exemption, really, you don't have a means to be able to go back to living individuals with that information. You wouldn't have that. So there's no link. So investigators cannot contact the subjects or re-identify, and they will also promise not to re-identify the subjects. So this is the provision 2. That is the most common exemption for provision 2 is the most common one that is being used for secondary research. And then there are two more provisions under this exemption that have come about in the under the revised rule. So investigators' use is regulated under HIPAA as healthcare operations, research, or public health. So HIPAA regulates how we handle the identifiable information. So essentially, the way that OHRP feels about this is that if something is already coming under the HIPAA regulations, right, for healthcare operations, research, or public health, right, then there's no reason for why the same human subjects activities will need to follow another set of rule, right? So that's really what it means. This means no need to worry about common rule if the HIPAA provision applies to you. So note that HIPAA only applies to information, not biospecimens, right? And so we're talking about HIPAA covered entities. So there are still a lot of questions. Okay, what about business associates of these HIPAA institutions and so on and so forth? And what about if we, HIPAA covered investigators now, can they share that information with people outside? If the people are outside in another institution are also HIPAA covered, or if the institution outside are not HIPAA covered, what does that mean? I'm not going to give you all the answers. OHRP is actually writing a guidance on that. But in the meantime, you can also consider, if you're interested in this topic, you can have a look at the discussion that the recommendations that came out from the Secretary Advisory Committee for Human Research Protections, CDRH, in 2017. And as they were coming out with that recommendations, Mark Barnes, who is a prominent member, ex-member, subcommittee member on SARCOP, he also did a presentation that you can watch the video of. And he did actually go into quite a lot of detail about all the different nuances and intricacies. So yeah, we're writing the draft guidance and hopefully it will be published at some point in time. So, and last but not least, I've not really come across the use of this very much, but it's the use of government data for research. Okay, I said that I'll talk a little bit about exemption 2 as well. Research that only includes education tests, surveys, interviews, and observations of public behavior when it falls into one of these possibilities. So when the information is recorded in such a manner that you cannot identify the individuals, or when the information, even if they're identifiable information, but then the disclosure of which would not, bring about harm to the subjects, harms like, civil liability or, employability, that sort of thing. Or it could still be sensitive type of information, and it's also identifiable. But now this is the expansion in revised common rule. So you can have an exemption if the information you're collecting, it's identifiable and sensitive, as long as you have a limited IRB review. And the IRB reviewer will specifically be looking at the conditions to look at would specifically be on the privacy and confidentiality protections, whether they're sufficient, whether they comply with what's stipulated under 46.111A7. So only consider the exemption when researchers will be interacting with people to obtain information. So this is about primary research, it is not about secondary research, right? So if it's a secondary research, you're not looking at this exception at all, right? You're really looking at when researchers are actually talking about activities where they go out and maybe do a focus group or interview or ask people to do a survey, right? So there are the interactions there. And notice that exemption to those things in asterisks, the surveys and the interviews, they do not apply to children. So in other words, when you are doing surveys and interviews and involve children, then this exemption will not apply to you. The other things, yes, if it's only educational tests or only observations of, you know, a child's behavior in the playground, yes, that's fine. So what is limited IRB review? I've alluded to this earlier. So this is not a standard IRB review required by the common rule for non-exempt human subjects research. So you do not need to review according to the full set of review criteria under 46.111. You have a designated IRB person. So it's an IRB member who would be doing this review. Only one person needs to do that. And all that person is doing is to make sure that the conditions that are described for that particular exemption provision are met. So for exemption 2, provision 3, this is when appropriate, there are adequate provisions to protect the privacy of subjects and to maintain the confidentiality of data. It is usually a one-time review with no requirement for regular continuing reviews of such. However, it's important for institutions to make their investigators aware that anytime that they change their protocol, something could change, and then this exemption may or may not apply anymore, right? So it's important to go back and ask the IRB office to make sure that that is the case. So like other exempt research, there is no requirement to submit something called IRB certification of approval to the HHS sponsor to receive the research money. I'm going to explain this bit a little bit more later. So just now, let's look at some case scenarios. Institutions A and B have access to clinical information of patients using an FDA-approved device available in the market. So clinical information of the use of this device being collected regularly. FDA now offers funding for researchers at these institutions to analyze the clinical data already being collected for the clinical care. This is secondary research because there's no intervention with the people to collect their data or biospecimens for that matter, specifically for the purpose of this particular analysis. Researchers at the institution, so the next thing that we know is that the researchers at the institutions do not themselves have any access to identifiable patient information at any time. So even though they work at the institutions, they're really just being provided with the clinical data without any associated identifiable information. So for the analysis, you can say they're kind of blind to who the people are. They will only be provided the data like I just said. So what is this? We just said, this is secondary research. And now this is secondary research without identifiable information. What does it mean? It means that they're doing secondary research that is not human subjects research. Okay. Let's look at scenario 2. And it's a build up, right? We had the previous set of facts, but this time we're told researchers at the institution, they're also clinicians and they have general access to identifiable information of patients who will be using this device. So you see how starting off, they have potential access to identifiers. So now what this means to us is that, okay, this is secondary research using information that researchers could potentially link to living individuals. They're using identifiable. So this is secondary and it's human subjects research. However, the next set of facts we found out is that for the particular required analysis, the data set for the research is recorded by the clinicians who initially have access, but the data set that they're using is recorded in such a manner that the identity of the subjects cannot be readily linked back to living individuals, and researchers will not re-identify or contact individuals. Remember this? What does it come under? So now we know is secondary research is human subject research. We'll ask the next question. Is it exempt? Does it fall into an exempt category? Yes, I think it does, right? It probably would fall into the exemption 4 category. So then it's exempt from the common rule requirements for the full board IRB review, et cetera, et cetera. Now let's continue with this way of thinking. All right, so now we know, okay, what is different now is that researchers actually want to retain the identifier. So it's not that they want to download a data set without identifier. No, they actually want to retain identifiers for the clinical information they will use for the analysis. There will not be any biospecimens involved in this analysis. So secondary research using individually identifiable private information, secondary human subjects research, right? Correct? If researchers belong to a HIPAA covered entity, right, and they may still be able to conduct the research under exemption 4, provision 3, the HIPAA provision. So the exemption 4 may still apply to them, right? In that case, then they don't have to think about the rest of the common rule requirements. If researchers do not work in a HIPAA covered entity, then an exemption may not be available for the work unless the individually identifiable clinical data came with an associated broad consent that meets the requirements of the revised common rule. So I haven't mentioned anything about broad consent, and I haven't said anything about exemptions 7 and 8, which are also exemptions that are used with secondary research. I have not mentioned them because you guys specifically told me that don't bother with that. And in fact, I also say, well, don't bother with that because not many people are going in that direction outside in the research community. It's just that with broad consent, the regulations have a full set of strict requirements as to what need to go into the broad consent. And you need to have it already, right? Collected and filed. Okay, so otherwise, without that, otherwise researchers will go through the formal IRB review and approval to do the non-exempt research. I've noticed that I'm going over time, so give me another 5 minutes. Hopefully I'll finish this for you. So scenario 4. Okay, based on the previous situations, now the researchers will also, because now they have identifiable information, right? So they have links and everything, and now they want to hire, in addition to what they're doing, the secondary analysis, they want to hire a survey firm to go out and ask a selected sample of the people in the data set who've been using the device some additional details related to their use, right? So there is now also patient interaction to collect data specifically for the purpose of this research. There's now both primary and secondary research involved. The primary interaction is human subjects research that likely could come under exemption 2. Notice I put adults here to help you, because just be careful. If it involves children, then exemption 2 would not apply. Now, so assuming that, yes, exemption 2 might apply to the part that is a survey, and then since the researchers belong to the HIPAA covered entity, we just said, and the research segment, the secondary research segment is likely to be covered under exemption 4, the HIPAA provision. So now you have a situation where the entire research project can be fully covered by potentially two exemptions, exemption 2 and exemption 4. Under this situation, if the whole research fully satisfies all the conditions for the two exemptions, this whole research can be considered exempt under the way we think and apply the common rule. If not, okay, let's say if the device is actually being used by children as well, and the survey would involve children, then your exemption 2 for the primary research part will not be applicable. That part will need to go through non-exempt human subjects. Because that part does not come under exemption, then the whole research project is kicked out of the exemption consideration, and the whole research needs to go forward and be considered as a non-exempt human subjects research that requires IRB review and oversight. Move on slightly to, and just the last few slides, common rule and the federal wide assurance. So when research is non-exempt human subjects research, those that require the regulatory IRB review, the regulatory prescribed informed consent, et cetera, and is funded by HHS or common rule agencies, right? So in other words, the common rule regulatory requirements would apply. In order to receive the federal funds for these type of research, the primary awardee, the institutions that primarily getting the money from the institutions, or any of the institutions that get money from the primary awardee, associated institutions that are actually getting the federal money to conduct the research, and they're conducting human subjects activities, right, non-exempt ones, then they must have or be covered by something called an active federal wide assurance. Active, it still is not expired, in other words, to assure, what it does is that they're assuring to the federal government that they will comply with this set of regulations. for the research. So OHRP has a responsibility for compliance oversight for all HHS-funded human subjects research, including those that are funded by NIH, CDC, HRSA, FDA, etc. So what if the research is outside of the common rule requirements? I mean, we've alluded to that over and over already. So it means that activity is not research, it's not human subjects research, or it's exempt human subjects research, as determined by how we've looked at the definitions and descriptions. In these instances, institutions are doing the research. Institutions doing the research do not need to have an active FWA, so they don't need to file anything with the federal, they don't have to assure the federal government anything. There would be no need to provide IRB certification of approval for the research, because the research activities that they're doing, it's not what it's called non-exempt human subject research, right? So the rules don't require that they go, they can pass it through an IRB, but the rules don't require them, and the government does not have this expectation. And if the government does not have this expectation, there is no requirement for these institutions doing this kind of activities to submit something called the IRB certification, because that's not required. So above is true even if the exemption determination involves that special beast, the limited IRB review, right? Even if it involves that, right? Like I said, it's not like the standard regular IRB review. It's really just limited to ascertaining that that condition that is required for that exemption is satisfied. And that being the case, right, the exemption applies, and exemption applies, it's outside the common rule, and therefore, there's no need for the IRB certification or the FWA requirement. So is an HHS agency engaged in non-exempt human subjects research? This is interesting. So I just want to talk a little bit, and this is probably my last slide. Examples below show some variations depending on circumstances. So NIH, NIH have the intramural program, right? So intramural staff at the clinical center, they're scientists, they're conducting non-exempt human subjects research activities. So typically, NIH would be engaged and would require to submit and have an active FWA, and that is indeed the case. Now, what about if the federal staff of an HHS agency designs a research project and hires contractors to conduct the human subjects activities, or pay some people, some institutions to do it, and then the institution analyze the data and so on? The contractor, the people receiving the money, right? The contractor is engaged in research and requires an FWA because, let's say they're not human subjects activities that are non-exempt. The HHS, what about the HHS agency that is funding it? So the HHS is probably not engaged and does not require an FWA, but this may change depending on how much more involvement there is by the agency staff in the actual research study. And with that, I'm thinking about, NIH has all sorts of mechanisms to fund research. And then sometimes, their staff are very, very much involved in the entire, design idea, and the setup of the research. Now, under those situations, even though, if it's done through a contract mechanism, not a grant mechanism, will the NIH staff also make NIH become engaged and have to file the FWA? And that things will come under us. It depends on the actual details, right? And then usually agency would have some sort of policy to make that determination. Now, in the case of FDA, and through our conversation with CDRH staff, with Rebecca, right? Our understanding is that your activities, you fund activities that are mostly outside, as far as we've seen, they're outside of the common rule, whether it because it's not human subjects research because there are no identifiable information that the researchers access, or that it's exempt because it comes under one of the exemptions, 204, right? We think that generally your activities are mostly outside the common rule. And then CDRH staff seems to have very limited involvement in the conduct of the research. Basically, you're just identifying, those institutions that have the data or something, and that you give them the money to do it. Thus, neither FDA nor the institutions conducting the research will be considered engaged for these activities, and neither will require an FWA. This is our understanding. But of course, now that you've learned how all these things apply, you can, see if it is the case still. just want to let you know that there is a OHRP human research protection training with 5 lessons that would go into a little bit more detail on the stuff that we've just talked about, and talked about IRB review and informed consent requirement and so on. And this is free of charge to anybody who wants to use it. You can use us, the research community, especially smaller institutions that don't have funding to pay for like a full city training program, then they at least can get basic training. And these are the contacts and resources. And I've told you about the OHRP 2006 guidance that we mentioned way at the beginning. If you're interested in that, you can look at it, and the link is here. And I think with that, I am several minutes over time. I hope that you still have time to stay with us for question and answer. And thank you very much for your attention. This has been useful for you all.
Great. Thank you, Yvonne. That was a really great talk. Thank you for putting that together and spending your morning with us today. So I think if anyone does have any questions, you're welcome to come off of mute and or pop them in the chat, and Soma and I can pose the questions to Yvonne. We have around 15 minutes left if we observe the full 90 minutes, or if we want to hop off a few minutes early to respect the CDRH take 10, we have about 10 minutes left. So maybe I'll pause there and see. Soma, do you have any initial questions for Yvonne?
Thank you, Yvonne. Oh, sorry. One second.
Yeah, I think the computer and the speakers are both on.
No, I forgot that I was connected on 2 devices. My apologies for that.
No problem.
And there was some feedback. This has been really, really great, Yvonne. A lot of great information, and just to provide a little context, I think, for many of the people who are involved, who are here today. We have primarily, I think, folks from a couple of divisions within our office. Some are actually involved in conducting this CDRH funded research that you've described, and some are involved in policy and compliance around FDA regulated studies. So people who have roles with the investigational device exemption policies, and our Parts 50 and 56 are informed consent and IRB regulations. We have our bioresearch monitoring colleagues on the call as well. Having an understanding of the common rule is very relevant to ensure that we kind of understand the context of inquiries that come in to us around research.
Yeah.
And so, I think there's great value. There's a lot of really great information that you provided. Thank you for putting together such a thoughtful presentation. And I just want to also, invite anybody from OSEA who's on the call, if, once you've had an opportunity to kind of think about and marinate on the great content that has been provided, you can also send any questions to me or Rebecca, and we can try to help get an answer to those. We probably will need to consult with Minerva. There's always, she's our regulatory counsel. There's always interesting questions about kind of the intersection of the
two sets of
HHS
rules.
regs and the FDA
Yes.
regs.
Yes.
And I think that's kind of one of the questions that was thinking about posing to you. It is, when you receive inquiries from researchers, within the HHS umbrella, who might be conducting studies that involve FDA regulated products, how do you advise them on knowing what regs to follow?
So, our office really stays within our jurisdiction very much. And it is true that we have an education division here, and we do go out and, do sort of many interactions with the research community. But we very much try to stay within our lane. And if they, if they do actually, I mean, we would alert them to the fact that, especially when it involves, an investigation of products or something that we're aware of, we would tell them that, there are other regulations such as the FDA regulations would apply. Now, we can't actually say any more than that, and we don't want to, because like yourself, right, we also just we have some inkling ideas of exactly what your regulations are like, and even though we would probably know where to go and look and read your regulations, but as with all regulations, right, it's easy to read the wordings, but whether your understanding really falls within how the regulators actually interpret that regulations, that could be variations, right? So we really try very hard to stay out of that completely and let people just ask, we send them off. So sometimes, OHRP has something called an OHRP mailbox. So it is OHRP@HHS.gov. It's easy enough to remember. And, anybody is welcome to send questions to that mailbox, including any of your staff who, may not know who to go through, or, you can just send it to the mailbox. And what we do is that if it's, strictly kind of within our jurisdiction, within our lane, we'll, answer it to the best of our ability. But then if we start to detect there's something that, other, specifically FDA regulations might apply, we would either tell them to go and talk to FDA, or we might, if it's really clearly that there needs to be an FDA perspective, we would copy the email to the GCP, FDA GCP questions mailbox.
Yeah.
And then somebody would get back to the person, and when that person responds to all, we actually get to see the response, and that's helpful for us to get a better idea as to how you guys think about things. Now, obviously, we are the education staff and we deal with that. We have the policy team people who have a lot more interactions with FDA in terms of, the harmonization project. So they have, more in-depth, usually, understanding of the FDA regulations. And similarly, I can tell you that recently, I think last week or the week before, our compliance folks also had, meetings with the FDA compliance group. I don't know which group that is. And, to learn more about how FDA handles audits and oversight monitoring. And to learn, what your system is like, because I also know just from attending that meeting on the side that, there is a lot of difference of how we see things. I mean, one obvious kind of perspective is that generally OHRP, sees this compliance activities, for example, as trying to make sure that if something problematic comes in, OHRP has an attitude of trying to work with the institutions to see where the problem was. What is the problem? Where was the problem? And how serious is the problem? And whether the problem is actually amenable to some measures that they need to put into place to make it better. And I think that we try not to go the route of being too sort of trying to find the right word, to like federal we're the federal regulators, we're kind of trying to ding you on these things and to find fault in what you do. No, we try really to to work with them within the regulations and see how they can come back into compliance, if you like.
Yeah.
So,
yeah, thank you. I think we also have a similar approach on the compliance side.
Yeah, I'm sure you have, just a slightly different way of looking at it, I guess.
Yeah. And I think that that all makes a lot of sense. It's good to know that you have relationships with our, I think they've changed their name. Office of Good Clinical Practice now has I think it's Office of
Yeah, I mean, I what is it? They call it.
Yeah. There certainly are kind of differences in interpretations. We, I think, in kind of responding to a couple of pieces of information in your slide deck, just for, the benefit of the FDA attendees. I think a lot of the research that we are conducting now currently, the MDE safety studies, for example, and much of the research generally just wouldn't fall under the Public Health Surveillance Authority. And so just want to mention to folks that if there is any need to do something that you think might fall under that authority, please do reach out. We probably want to discuss with Minerva and see what is the appropriate authority for us to obtain that data. And of course, there are other. Yeah, go ahead.
Yeah, so I'm glad you mentioned that, because as I was developing this presentation, I got to public health surveillance. Oh, this might actually work for some of the activities. And I actually went to ask my OHRP policy people, how you guys interpret this and what you do. And I mean, I got the same message. Basically is that, your agency, some group in your agency needs to come up with, your policy as to how you would interpret and apply that, right? It is something that CDC is very relevant to the work that they do. And since, we were kind of coordinating with all the common rule agencies, right? People have different asks and different interests. And so for this particular public health surveillance carve out, right? The biggest interest and relevance probably came from CDC originally, right, for the work that they do. And yes, to a certain extent, right, it may apply to some of the work that you guys are doing. And that's why I did have the opportunity to ask, Bridget Fultz, who is at the Human Subjects Protection under the the Office of the Chief Scientist, right? So she was saying that, if people have questions, let them come to me and I'll try and coordinate and find out what's going on. But as far as I know, yet there's not a structured set of policy that has been developed yet. So I think that people shouldn't just go and say, it applies, let's just use this now. I mean, we joke about it, right? In theory, right, potentially, if you interpret this very broadly, much of NIH sponsored activities could come out of public health. And there are people who try to squeeze it through that one, right? So that doesn't make sense at all.
Yeah, no. Thank you, Yvonne. That's great. I'd just like to add that, we have some other work with NEST and other activities. At the moment, it's really great to hear about that, how that regulation could work. We haven't activated that for any of the work that we are doing in OSEA at the moment. If that changes, it might, but I think that, internally within CDRH, we would need to follow all of the right steps and elevate it to the right folks in leadership to ensure visibility and concurrence on those types of things. So at the moment, our work is not covered by that, or we're not activating or leveraging that regulation for our really important work that we do. So we're at 10:26. So I think we'll respect our CDRH Take 10 here. We're 1 minute over. So with that, I'd really like to give a really great thank you, Yvonne, for putting this together, doing a lot of background research on preparing this slide deck and spending your morning with us today on Wednesday. It's been really a significant amount of information was provided. I think we'll also thank you for recording this so our folks can, take a step back and maybe rewatch it a few times. We'll definitely distribute that and find a way for all of our folks to be able to access it and watch this again. I do think this is very needed and definitely very informative. So thank you again for doing all this great work with us. And I hope we can collaborate again in the near future. Soma, just will give you the last word here and see if there's any other things that you'd like to mention.
No, your last words were great. Thank you so much, Yvonne, for joining us and preparing this for us.
Now, Soma and Rebecca, thank you very much for reaching out to us and having us organize this. We've really enjoyed working with you guys, and this is really one of our interests as well, try to support our sister agencies. Thank you so much and have a good day.